are some strange laws that exist just because of one singular weird court case. Number 1, SteamySnuggler.
Number 1. Tomatoes are vegetables.
Wait, tomatoes are vegetables? I thought that was because of biology. What do you mean it's because of a law?
1893, Nick's brothers were importing tomatoes into New York. At that time, the U.S. had a tariff on vegetables, but fruits could come in for free. So they looked at the law and thought they had found a loophole. Botanically, tomatoes are fruits. They grow from flowers, they have seeds, they're basically equivalent to apples. So they refused to pay taxes, but the customs collector disagreed, and the whole thing ended up at the Supreme Court. His entire argument was that tomatoes get eaten with dinner, not dessert. They go with meat and potatoes, not apples and oranges. The Nix brothers, on the other hand, came prepared with dictionaries and botanical experts. They proved to the court that scientifically, tomatoes are fruits.
Okay, so it is based on science, but there was a huge Supreme Court case law around this? What is going on? Dude, I cannot... Anything to avoid taxes, am I right? Anything to avoid taxes.
They grow from flowers, they have seeds on the inside, and they fit every botanical definition of a fruit. The Supreme Court looked at the matter and ruled for tariff purposes. The argument was the use of common sense. The stuff you eat with your entree is vegetables, and the stuff you eat afterward is fruit. And the case was closed.
Wait, what? They ruled it as a vegetable? What? This is like a open and shut case, no? And he cited common sense? Brother.
The Nix brothers lost the lawsuit and had to pay the tax. The rule started being used from there onward and is still taught in law schools today. Used as an example of how legal definitions don't have to be scientifically correct.
Wait, so in America, the tomato is still considered a vegetable in the eye of the law, even though everyone knows it's a fruit, just because it's common sense? ? Oh my god.
Number 2, advertisement aren't real offers. In 1995, Pepsi ran a commercial that would accidentally create a law about advertisement. In the ad, Pepsi
I heard about this one thing.
Showed teenagers racking up Pepsi points by drinking soda, and you could trade those points for prizes. Sunglasses for 175 points, a leather jacket for 1,450 points. But in the end of the ad, they showed a Harrier fighter jet landing at a high school, and it went for 7 million Pepsi points.
That's 700 million. 700 million Pepsi points for a Harrier fighter jet. How much dollars is 1 point?
Million Pepsi points. Pepsi was being absurd on purpose. Except one guy didn't think it was a joke. John Leonard, a 21-year-old business student, saw the commercial and made a commitment to get that jet. Here's the thing. Pepsi points could be purchased directly for 10 cents each. That meant the Harrier jet, worth about $23 million, could theoretically be obtained for $700,000 plus the cost of 15 original Pepsi points. Leonard convinced a group of investors that this was a deal of a lifetime, and they wrote Pepsi a check, sent in an order form demanding their Harrier jet. But Pepsi sent the check back with a letter saying they were just kidding and never meant that a person could win the jet. Leonard wasn't backing down and went ahead to sue Pepsi for breach of contract and deceptive advertising. His argument was,
this seems pretty cut and dry. They should get the jet now, or at least get the monetary value of the jet, I guess. But this is pretty cut and dry now. They advertised something on TV. Someone took a rapid offer.
Pepsi had made an offer in their commercial. He accepted it by meeting the terms, and they had a binding contract. But the judge ruled that no objective person could reasonably have concluded that the commercial actually offered consumers a Harrier jet. The decision created what's now called the reasonable person standard for advertising. If a normal, reasonable person would understand that an ad is a joke, then it's not a real offer, even if the company technically stated the terms.
How is an ad a joke? How is an ad a joke? It's literally an advertisement. You are advertising an offer. How is it also a joke? Okay, bro.
Number 3. Pringles are potato crisps. Pringles have always been weird. They come in a can. They're all the same shape. They don't really taste like other chips. For years, Procter & Gamble, the company...
That's because Pringles are made different. They're made from a potato, like mash instead. They're not made from shaved potatoes. Like normal potato chips are just shaved potatoes, but Pringles are like formed and like a mash. Like a mash, I don't know.
The company that owned Pringles leaned into that weirdness, marketing them as different from regular potato chips. But in 2008, things got a bit weird. You see, in the UK, most food is VAT-free because the government considers basic food a necessity that shouldn't be taxed. But there's an exception. Luxury foods get taxed at 20%. And according to UK tax law, potato crisps count as luxury items. The company argued that Pringles shouldn't be taxed as potato crisps because, technically, Pringles aren't really made from potatoes in the traditional sense. They are majorly made from dough, and with only 42% potato content, they were more like a baked good than a crisp. However, the UK tax authority refused the argument and stated that if it looks like crisps, tastes like crisps, then it is crisps. The potato percentage doesn't matter.
Oh my god, this is the same thing with the tomato. It's the tomato all over again.
Like crisps, tastes like crisps, then it is crisps. The potato percentage doesn't matter and tax is inevitable. The situation escalated to court, and in 2008, the company actually won. The court ruled in their favor, deciding that Pringles were not potato crisps for tax purposes. But the tax authority didn't back down and had to make sure the tax is inevitable. They appealed to a higher court, and in 2009, the Court of Appeal overturned the lower court's decision, ruling that Pringles are, legally speaking, potato crisps and should be subject to the full 20% VAT. The judge...
I will point out that this is the second time in this video. These high-profile single-case rulings are all for taxes, by the way.
Legally speaking, potato crisps and should be subject to the full 20% VAT. The judge acknowledged that Pringles are made differently, but a person would consider Pringles to be potato crisps, regardless of the manufacturing process. Number 4. Animals can't own copyrights. In 2011, a British wildlife photographer named David Slater was in Indonesia taking pictures of endangered macaques. When he set up his camera on a tripod and walked...
He's what? Endangered? He's what? He's what?
Was in Indonesia taking pictures of endangered macaques. When he set up his camera on a tripod and walked away for a bit, a curious monkey grabbed the camera and started pressing random buttons. The monkey took hundreds of photos, including several perfect selfies. David published the photos, and they went super viral. Then Wikipedia uploaded them to Wikimedia Commons and labeled them as public domain. Slater was furious and argued that he owned the copyright because he set up the shot, created the conditions, and owned the equipment. But Wikipedia disagreed, claiming that since Slater didn't actually press the button, he didn't take the photo, which meant there was no human author and therefore no copyright. Then things got really weird. In 2015, PETA, the animal rights organization, sued Slater on behalf...
Whenever PETA is involved, man, it turns to shit, man. Whenever PETA is involved,
weird. In 2015, PETA, the animal rights organization, sued Slater on behalf of the monkey. They literally filed a lawsuit claiming that the monkey owned the copyright to his own selfies, and that Slater had stolen the monkey's intellectual property. The argument was that the monkey deliberately composed the pictures and therefore should be treated as the legal author with all the rights that come with it. In 2016, a judge dismissed the case, ruling that animals don't have legal standing to sue for copyright infringement. The judge pointed out that copyright law is designed for humans, by humans, and there's no indication the Congress ever intended to extend it to animals. The ruling now affects all kinds of edge cases. Even when your dog accidentally takes a photo by stepping on a phone, the photo doesn't belong to you and nobody can own it. Number 5. Corporations...
Oh, so it ended up with no one owning it? It ended up with no one owning it? So it's common ownership? It's not the photographer or the monkey. Okay. Corporations are people! No! The worst thing that ever happened. Corporations are
Nobody
people
can
now.
own it. Number 5. Corporations are people. In 1886, Southern Pacific Railroad didn't want to pay property taxes in California, so the Supreme
Taxes again! It's always
Court
taxes!
heard a case to decide whether the county could tax railroad property. But here's where it gets weird. The Supreme Court ruled in favor of the railroad on narrow technical grounds that had nothing to do with corporate personhood. But before the oral argument started, Chief Justice Morrison Waite made an offhand comment to the lawyers in the courtroom. He said something to the effect of, "We don't need to hear arguments on whether corporations are persons under the 14th Amendment. We all agree that they are." What is interesting is that the comment wasn't part of the official court opinion. It didn't appear in the legal reasoning, it was just a side note before the arguments. But the Supreme Court reporter added Waite's comment into his headnote for the case, saying that the court had decided corporations are persons under the 14th Amendment for equal protection purposes. Later on, courts built on this idea until the 1970s when courts ruled that corporations have First Amendment rights to political speech, meaning they can spend unlimited money on political campaigns because restricting that would violate their free speech. Number 6. Jaffa cakes.
That's the problem right there, man.
Number 6. Jaffa cakes are cakes. In the UK tax system, cakes are considered a staple food in our...
It's more oh my god. 4 out of 6 of these cases are taxes. 4 out of 6 are taxes. Is taxes really that big? It's not that serious, man. Just don't pay them.
And subject to VAT. Biscuits, what we call cookies, are also usually tax-free, but here's the gotcha. If you cover a biscuit in chocolate, it suddenly becomes a luxury item and gets hit with 20% tax. Then there's the Jaffa cake, a circular cake-sized base with a layer of orange jelly and chocolate coating on top. McVitie's had been selling Jaffa cakes since 1927, treating them as cakes and therefore being tax-free until 1991, when UK tax authority decided that Jaffa cakes were biscuits and should be taxed.
What?
McVitie's
Those are not cookies, brother. Those are not cakes. Those are cakes. Those are small cakes,
disagreed,
brother.
and the case went to a VAT tribunal. On the actual hearing day, McVitie's brought in actual cakes and biscuits to court to demonstrate the physical differences. But the turning point for the case came when they demonstrated the staling test. When biscuits go stale, they become soft, but cakes go hard. On that ground, the tribunal issued a ruling that Jaffa cakes are cakes because they share more similarities with cakes than biscuits, and the chocolate covering was irrelevant.
You can see their cakes.
The ruling created a legal standard that other companies immediately started exploiting. Any product caught between categories now had a playbook to present ingredient analysis, demonstrate texture change patterns, and argue consumer perception.
That's fair. Yeah, got all the reaction done. Thank you guys so much for watching. If there's anything else you guys want to watch, anything else you guys want me to react to, drop in the comments below. I stream almost every day of the week over on twitch.tv/SteamySnuggler. Feel free to drop me a follow, drop a subscription, drop a like. I love you guys. I'll see you around. Kiss, kiss, kiss.